Welcome to another episode of The Untitled Legal Attempt. It's our first episode of 2020, so Happy New Year! Yes! Well, thank you for being with us last year with the few podcasts that we had, and thank you for listening to our first episode of 2020. My name is George Chintankwa Malepilo. Once again, welcome to The Untitled Legal Attempt. Twabuela na fire! Alright, welcome back. That was an intro. Okay, so today's case is titled New Plast Industries v. the Commission of Lands and the Attorney General Supreme Court Judgment number 8 of 2001. The importance of this case looks at the mode of commencement when initiating a suit before the High-Court of Zambia. Basically, how do you sue someone who has violated your rights? What is the correct procedure? And also it related to when do we use English laws that are being practiced in the courts which are similar to that of the High Court. So it's the High Court of England. So when can we use the practice and procedures of the High Court of England in our country? So with the first issue of mode of commencement, the appeal that was before the Supreme Court was as a result of a preliminary issue that was raised in the High Court, and there was a ruling. The ruling stated that New Plast Industries should never have commenced judicial review against the action of the acting Chief Registrar of the Lands and Deeds Registry. The short facts were New Plast Industries were owners of a property which they had bought. Then flags were raised to say it was a fraudulent purchase from other parties. So the acting chief registrar decided to cancel the title and asked them that it should be brought back. All right. So as a result of that action to cancel, that is why they initiated judicial review. Now, the Commission of Lands and the Attorney General said, no. This is not the right procedure. That's where the preliminary issue now was raised, to say the Act under the Lands and Deeds Registry does provide under Section 87 for how you bring this particular type of matter against the Chief Registrar of the Lands and Deeds, which is through an appeal. You don't commence judicial review proceedings, no. So the judge agreed with the Commission of Lands and the Attorney General on this particular preliminary issue that was raised. Now, a preliminary issue is basically one party raising a concern to say, we've read these submissions, but we have this urgent application we've made for you to look at. Maybe because the parties that you may have sued are not parties to the matter. So you raise the issue, say, these people are not party. So it's just basically you raising notice to the judge about a certain matter before you go to trial. Are there any irregularities that you want to raise? Is there any issue relating to the case that you want to raise? That is where the preliminary issue is raised. So whenever you hear there has been a ruling, it's a preliminary, it means it's relating to a preliminary issue and that matter has not gone for trial yet. So it can't be a judgment. Now, this preliminary issue, however, bordered on the commencement of how the matter was commenced. So the court said it was irregular and therefore that matter could not proceed because that's not how the law provided, so the court had no jurisdiction. So they had to throw it out. Now, when we get back, we will look at the decision of the Supreme Court in relation to the appeal that was made by New Plast Industries and the importance of this case overall. For now, let us enjoy some Ben sound, of course. welcome back. That was some smoothing Ben sound summer. So, we're now in the Supreme Court, the apex of the court system. This delicate, wonderful. I mean, it is, in my view, the creme de la creme of the court system. Yeah, because it's the top. Okay, enough of the praising. So, this matter went before the Supreme Court. The argument New Plast Industries gave to the Supreme Court the argument that they gave was that the mode of commencement should look at the relief being sought. So meaning, what are you asking the court to do and nothing else? Well, the other party said, no, that's not true. Section 87 does provide for the practice and procedure of the High Court and how this matter was to be commenced. It was not supposed to be commenced through judicial review, and the judge was right when he said this matter was irregular, or it was brought in a manner not acceptable before the court. Those were the simple facts that I've summarized. Again, I repeat, go read the whole judgment and understand. I have a limited number of time, so I'm basically picking out the most important issues. But when you read the case, you have a better understanding. So, this case, when decided by the Supreme Court stated that at no point would you ever commence a matter based on relief being sought. No. They stated the fact that you have practice and rules that are provided for, that stipulate how a matter will be commenced in the High Court. Not the Court of Appeal, the Supreme Court, High Court. These two are Court of Appeal. These two are appellant courts. But you could also say when you make an appeal to these courts, there's a manner in how these appeals are made. But when you are commencing the matter, there's a manner in how you take that matter before that particular type of court. Alright? Yes. They refer to Section 10 of the High Court Act, Chapter 27 of the Laws of Zambia, and stated that the High Court Act clearly specifies that practice and procedures concerning the High Court will be as stated under the High Court Act. So meaning the subsidiary rules as well. So how you commence a matter is provided for under the High Court. That's one. Also, other written laws also provide for the practice and procedure of the High Court. So when commencing a matter, it's not just the High Court Act itself. Other written laws. In this instance, Section 87 of the Lands and Deeds Registry Act provides for how you bring the matter before the High Court. Article 28 of the Constitution of Zambia provides for how you bring the matter before the High Court. So, in a nutshell, the mode of commencement of any matter is not you deciding through relief or you deciding based on the facts, but it is the law that has stated how you commence the matter. And you therefore have to look at the enabling law that creates that court. The High Court Act creates the High Court of Zambia, and the High Court Act therefore entails how practice and procedure relating to the commencement of matters is initiated, or any other written law, any other written rules. So it's not just High Court Act in the end. Now, the High Court Act also talks about the fact that this act in itself may not be adequate and may be silent. Therefore, in those two instances, there must be a substantial conformity with the rules and practice that are being observed in the High Court of England, or as the law states, in the High Court of Justice. So what they are saying is that our laws or our practice and rules of the High Court will have certain gaps. It will have certain rules or practices that are not specified. And because those rules are not provided for in our act, we shouldn't struggle. we should then refer to what rules and practice are being observed in the English courts at the time. Substantial conformity. Follow what's there at the time. Now, when we talk about when the act is silent, or when the act is not comprehensive, what I mean is, for example, the High Court Act has the High Court rules for practice and procedure in our country. The Act does provide for how you sue a party, the modes of commencement, but it does not provide for how you commence a matter against a public body, or how you sue government officials. It's still the same thing, a government body. Okay, parties to a matter, the mode of commencement is there, but it's not that clear. Okay, not that essentially clear. So in that event, because it is silent, we have to now go and ask ourselves, okay, what is the law and practice in England when you are suing, let's say, the Ministry of Finance? Not the Ministry of Finance, you can sue them as a party. Let's say the Ministry of Defense. Okay, or maybe you want to sue the Minister of Information because your rights have been violated. What is the practice and the procedure? Order 53 of the rules of the Supreme Court clearly state that, and that is what we use because our laws are not in conformity. The cases of Dini Mungomba and Peter Machungwa to this effect can also be added here because it said our laws are not comprehensive enough to provide for how you sue public bodies. So we rely on the rules and the practice that is in England, or the practice and procedure in England. And when you look at that, you'll find that it's Order 53. So therefore, in ending, the significance of new Plast Industries v. the Commission of Lands and the Attorney General to the legal hemisphere of our country was this case stated without a doubt that when you are commencing a matter, the matter is commenced as a result of what the statutes of our country, if I can use those words, have stated. Meaning the law, and only the law, provides for how you commence a matter. And you have no option. You can't choose. And it is not determined on the facts or on the parties the statutes provide. Furthermore, you could argue to say the practice and procedures of how a matter is commenced is not only in the High Court Act or the subsidiary rules, but other laws also provide for the practice and procedure. And even though those practice and procedure are not in the High Court, but in that other act, you must follow what's in that other act. 2, when our laws are silent and less comprehensive, when it comes to practice and procedure, we must follow those laws, those practice and procedures that are currently being used in the United Kingdom. Now, the White Book is no longer part of our laws. We use it as, like I have said, when it's silent or it's not that comprehensive. We don't use it as it was stated in OKT Limited and Amanita. The law has now changed. There was an amendment that was made to this effect to the English Extant Act of Application, I think chapter 11, to revert it back. So, thank you very much for listening to our first episode of 2020. I hope you will be listening to more of us. From me, George Tintankwamali Pilo, I would like to say thank you very much for being able to listen to us, and I will see you next time. Remember, legal awareness is very important.